Let me get this straight. You blew up a building.
2 CIs and the CEO of 22andU.
2 competing federal agencies with the same mission.
I don't understand why those Fed a-holes are so darn mean.
To protect the public from the scourge of dangerous misinformation.
You know those bum idiots. This is all them. We had a solid case.
The word entrapment, not even in their vocabulary.
The explosives we provided were fake.
Sworn to a duty to always tell the truth.
We have no indication at this time that this was a deliberate act.
We're all being transferred.
To where?
The only place currently with openings. Alaska.
Good morning.
Welcome to the office, huh?
And we got the retro feel. You know, the funny about federal buildings, they're all different, but they're still somehow all the same.
Oh, good morning, Agent Walker. At the coffee station. We actually drew straws before he got here, and I won, so we get to work together.
Let's get started. Let's see if we can't stir something up.
Let's give it a minute. I like to warm up the truth muscles, a little coffee beforehand.
Well, what do you want to do first?
What do we have for a surveillance van?
Oh, wow. I got a Ford Explorer. We don't have a surveillance van.
Do you put many cases here?
Cases?
Yeah, cases. We're the tip of the spear when it comes to protecting American democracy.
You really believe this? You really believe that people posting crap online is going to cause our country to crumble?
I think the work that we do is important.
We don't have a surveillance van.
Me and some people got one. We've never needed one.
We need a surveillance van. We need a big case or a CI who can lead us to a big case.
What do you need the van for?
Surveillance.
CIs, or confidential informants, are the lifeblood of any good law enforcement agency. Public posts on social media are one of the best ways to find CIs. Agents would never use coercion or take things out of context to try and persuade someone to become a confidential informant.
The new Taylor Swift single is absolute fire. I'm just seeing a lot of incendiary and violent language here.
Agents always need to be on their toes and ready to make snap decisions.
Is there anything I can do for you guys?
Actually, David, there is something you can do for us.
Chicky nuggies.
Chicky nuggies?
What?
Cheeseburger.
Cheeseburger. McDonald's cheeseburger.
Burger King.
Burger King cheeseburger.
Flame broiled.
And chicky nuggies.
Oh, baby, know you're gonna like it. I wanna be your beaver pilot. Said, honey, know you're gonna like it. I wanna be.
Awesome, right?
Is this a loner?
This thing's totally legit.
What is this? It's got windows!
All right. Welcome. Good evening. Welcome to the show. There's me, Robbie, and there's Finney at his place on the carpet or on the dog bed. We are just kicking it. It's hot here today, believe it or not. I'm in Alaska, but yet it's hot here. That's good because we have not had a warm day yet. Well, I take that back. We've had a few warm days, not very many. But today is actually warm. Hello. How are you? Yeah, no, I was stuck inside all day and I'm stuck inside here. But what do you do? At least it's nice out there. Through my curtains over there. Oh, anyway. So, yes. Welcome. We've So, yeah, surprising yesterday as we talked that there is no more trial. It's done. We had a conference today to set the charging, it's called the Charging Confident Conference. And I missed part of it, so we'll actually kind of go over it a little bit here because, you know, it started earlier and I woke up. Like I caught most of it, but there's some I didn't catch. And I think we'll watch some of Emily's broadcasts, and even though she interrupts quite a bit, we can speed it up and then we can go from there. I'm looking for oh man, the phone's over there. Okay. So yeah, we are kicking it here. So we'll get started and some other folks will come wandering in here after a while, I'm sure. Hopefully, maybe. We'll see. Who knows? Could be just us. I don't know. I never know. But we'll see. Before we get started, I do remember a couple of years ago, God, it seems like a couple of years ago, that the reason that the feds were looking into Karen Reed was okay, we don't know exactly why the feds were looking into Karen Reed. There are speculations out there, and they fit one of two ways. So there's speculation, but it's very educated speculation, and it fits two ways. One, Yannetti knew Josh Levy, who at the time was the U.S. attorney for the Northeastern District. He was in Boston. A guy named Josh Levy. Yannetti knew him. Yannetti's like, man, this case is messed up. Took it to Josh Levy and said, you guys should look into this. And then so the FBI started looking into Norfolk County, whatever you want to call it. And so then they discovered, oh, holy shit, you've got this young girl who was killed too, who was groomed by another police officer. She was killed in Canton, but the police officer was from Stoughton. And so the feds started investigating. Well, why wasn't he charged, right? Why wasn't he charged? And it just it's such a sad story. We went over it and over it. Well, the feds finally charged him officially today. And I got this pulled up here. But there's a catch. So Sandra Birchmore was pregnant. Sandra Birchmore was all the texts that Norfolk County missed all these texts. There was on the day that she passed away, there's video of what's his name? Matthew Farwell. There is video of Matthew Farwell getting on the elevator of her building. The feds got it from the building superintendent. Why did the Massachusetts State Police or Norfolk County District's Attorney's Office or the Canton Police, Sergeant Garano, who downloaded and missed all the messages, how did they not find a surveillance video from that day of the officer in question of this thing going? Because they did, or they didn't look for it, or they just said, yeah, she did it herself and we're going to go on our day. Still heard nothing from the corrupt bastards in Norfolk County or Canton. We've heard nothing from them. So hopefully once this disposition with Reed is done, I hope the feds come cracking down on this place because, my God, it's a mess. But we do find out, one, he is officially charged with her, but two, and she was holding this baby over his head. Well, the DNA shows it wasn't his. are we going to find out eventually whose it is? Because most likely it's another police officer from Staunton or from Canton or from, one of the incestuous mob of really, really sick cops. So hopefully we find out more, and hopefully this young lady who just had her parents were, she had a rough life. She did. And then she went into the Police Explorers program thinking that she could maybe find some way to make it out of a tough life and do some good. And this is what happens, right? Yeah, exactly. Oh, that was the cops putting it out there to try to get her to, try to get Reed to, that was either Proctor or somebody along those lines. So DNA testing has shown the former Staunton police detective accused of killing a pregnant Sandra Birchmore did not father the baby she was carrying. People who spoke on condition of anonymity told the Globe that the analysis excludes Matthew Farwell as the father. A federal grand jury last August indicted him on a charge of killing Birchmore, to which he has pleaded not guilty. It's unclear if authorities have determined the child's paternity. I'm sure they're looking. I am sure they're looking. Yeah, no, exactly. And the problem with federal court is it's not on. We're not going to see it. There's no video from federal court. You'll get people reporting it, and hopefully somebody I hope Jessica Mercado follows this. I hope somebody follows this case, and when it goes to court, they're in the court. But yeah, I think it's sick. It's so sick that this guy did this stuff. Of course, I can't make it any bigger. And the Boston Globe sucks because they're got this, thing. So yeah, so that came out today. That was kind of a shock that basically the DNA came back that it wasn't his kid. He did this for nothing. And he's going to rot in prison for the rest of his life, hopefully. And I like this one. Remember the time that John Fanning, Nick Garano, and Michael Lake covered up the murder of Sandra Birchmore to protect pedo Matthew Farwell? Well, we do. Yes, we actually do. We do remember that. So, yeah. Mm-hmm. The feds got the video from her apartment building. The superintendent gave them the video. So was it first the retrial got them turned on to Sandra Birchmore, or was it Sandra Birchmore that got them turned on to the retrial to say something's going on in this little podunk place that is just incredible. Oh yeah, no, there was somebody else. So it okay. So yeah, allegedly. Okay, you're right. Allegedly, no. So there is a X account called Justice for Sandra Birchmore, and she said she also has sources that say that is the case. So kind of leaning to let's see. Yeah, so Justice for Sandra Birchmore, who has had a lot of scoops on this thing, says, yes, I personally confirmed that it's true. I can't divulge my sources, but it is 100% true. So it's It's been X confirmed. So I guess, for the government, the U.S. attorneys have not come out and said anything, but I would think that person has their finger on the pause. Yeah, no, and that's what she said. She has her own sources. It's not the two people. So yeah, that's why at first I was like, okay, yeah, because a lot of people were saying the same thing. It's like, we've heard other things before, but yeah, no, she came out, and when I saw that, I'm like, oh man, this must be true. So yeah, crazy. Yeah, no, exactly. And she didn't post it. She put it as a reply. She put it as a reply to somebody else's post. So, all right. I have decided. I haven't decided completely yet, but I think for like news information and what's going on in the world and all the absolute nutty craziness that we are seeing right now, there is an account on X where I think I'm just going to go to this account and get my history information, my news information, everything that's going on in the world, because it's all a fucking mess right now. Excuse my French. So why not do it with someone who is basically a complete troll? This is 3-year Letterman, a youth football coaching legend, diehard Georgia fan, which in real life he is. The 3-year high school football Letterman. So what this guy does is he posts the most absurd stuff. He gets all his facts about history completely wrong. He gets all his facts about the Constitution, who's in what position, how they spell their name. There's a whole lore around this account. It's 467,000 followers. There's actually a show that was put together about this guy. So it's a thing. So you saw the crap with the senator today, right? So a person takes off any identifying clothing. He takes off his badge that says I'm a senator, right? The senators have a particular badge or a particular pin that they wear. That's like a security pin that shows hey, I'm a senator, right? I'm an elected official in Washington. And there's a commonality in things, and senators have meetings all the time with cabinet officials and whatnot. Well, today you had Senator Padilla from California take off any kind of identifying thing, rush into a press conference that's ongoing, and start screaming at the DHS secretary. So her security is confused. They don't know who this person is. He has nothing identifying him as anything. So that was complete just showmanship. That was just getting a reaction. So now they can run around and scream and cry, and it's stupid. It doesn't do anything. This is not how we actually get stuff done, by just making these big giant scenes. It was completely stupid. And the people had a right to act the way they did. Her security had a right to act the way they did. But I'm going to follow this guy because this is what he posted. And he waited. He said, oh, I'm going to find it here. Give me just a second. He really loves to go after cat turd. Oh, damn it. Where'd it go? All right. Okay, so yeah, so this was Senator Padilla posted this. If this is what they do to a United States senator with a question. Now he ran in there screaming and yelling and tried to rush the podium during an official press conference. There was no Q&A going on. There was no meeting with the senator. I've said this a lot recently, and I will keep saying it. The Constitution, Article 1 of the Constitution, talks about the House and the Senate and the Congress, right? Our legislative branch. They talk about the branch. They talk about the body. They talk about the deliberative body of people that get together and make the laws and spend the money and do all the things. Their power is in the body. It's in the body of the Senate. It's in the body of the House. It is their power comes from when they have a quorum and when they can vote on bills and when they can vote on, whatever. But the deliberative process of them being all together. It even says in the Constitution that you could have smaller groups, break off and put groups. Individual members of the Senate and individual members of the House have zero inherent power to do anything. They just don't have, they can't pass a law by themselves. They can't execute a law by themselves. They can't enforce a law by themselves. They have no inherent power themselves. So when they run into a press conference that somebody is giving a press statement, take off any kind of identifying thing. I had a polo that said I was a senator on under my jacket. It's just stupid. It doesn't move the ball. It doesn't do anything. Not the way, if you disagree with how the DHS secretary is doing things, this does not move the ball. This just makes things worse. So I'm going to start getting everything from 3-Year Letterman because he's about as right as anybody in this thing. What did he say? So let's say Senator Alex Padilla, if that's what they'll do to a United States senator with a question, imagine what they could do to any American that dares to speak up. All he did was get kicked out of the meeting, put in handcuffs for a minute, and then they let him go and he had a meeting with her. We will hold this administration accountable. Okay, you didn't do anything. You didn't make a this did nothing. Except inflame things anymore and give you some press. That's all it is you, Senator Padilla, were mad because not enough people were paying attention to you. So this gets people to pay attention to you. This gets you on CNN. This gets you on MSNBC. Congratulations. You're making the rounds of the press. Aren't you freaking happy now? So, like I said, 3-Year Letterman's got it better than anybody. Senator Alex Padilla. The First Amendment protects private citizens, but a state senator like yourself is not allowed to question a federal official. As a licensed notary public, I can tell you that legally, she is your boss, and you must do what you say. I think she said what she says, but you should be ashamed of yourself. And this is what he does. And of course, the people think this is serious because if somebody writes something online, they're serious. There is no parody online ever. And so people just lose their mind at this guy. Oh my God. So KD, you should be ashamed of yourself for posting something so incredibly ignorant and stupid. And then ZP, how do those boots taste? Like I wore football cleats to work today, not boots. No wonder you're a high school football coach living off bygone dreams. You can't tell your blood from your elbow. He's like, I'm not a high school coach. I'm a youth football coaching legend who's won so many championship rings. You need an accounting firm to count them all. So this is it. I've been meaning to do this for a while. I've been meaning to talk about this for a while because I'm so done. Here we go. Turns on notifications for Alex Padilla. And here we go. And I mean, it just, all these people just freaking lose their mind. They lose their mind over this, guys. It's hilarious. It's just hilarious. So, I mean, if you just get sick of it all, if you get frustrated with it all, go find 3-Year Letterman because it's good. And then I think he even had something about the he reposted the KD one. Tonight is the word. This is somebody else, Burt Macklin. He's kind of a same parody account that makes fun of stuff. Tonight is the World War III influencer Super Bowl. It sure is. And then this is a very, very observant statement. Tonight marks the 100th World War III of the last decade. I would say the last, 20, 30 years, maybe since 2001. But, I get the sentiment too. It's the last decade. Yeah, we probably had, more than 100 World War IIIs in the last decade. So, yeah, I mean, we can yell and do all the stuff, but we can't really do anything except just and yes, it's very childish. Okay, I will admit it is childish as hell. All right, it is childish as hell, but I don't care. I'm gonna do it. So yeah, follow that. All right. Speaking of childish, I had another one pulled up here. Let's see. Then we'll get to the thing, and it's not that one yet. We'll get to that too. We'll get to that too. Oh, damn it! Where'd it go? No. All right, hang on. Please tell me I bookmarked it. Yes. Okay, this is Carrie True Crime. She reposted this. And, oh my God, I saw a longer one. Damn it. I got to go find a longer one. All right. But she posted this. Well, remember old Judd.
What happens when I spread my load out, when I lay in my bed like this?
Oh, gross.
Yeah. What happens when I spread my load out, when I lay in my bed like this?
Oh, gross.
I love that one. Oh my God. There was another one. There was another. Oh my God. I got to try and fucking find it now. Yeah. And then we're screwed. So, I mean, if it does, it does. If it doesn't, it doesn't. Oh yeah. No, China would love this. But I don't know. See, I don't know. It's tough to say because, and I'm saying because, yes, it is what Israel has done tonight is a big step, and it's a big step towards a more broader engagement. But that is such a deciding factor, and especially if we're talking a non-nuclear confrontation, an analog engagement, I guess you'd say, or a conventional forces engagement between different countries, whatever countries come about, then that's a big step from a regional proxy war. So there's a calculation there that has to be done by Russia, by China to go there. So I guess it's going to depend a lot on how we react as a country, how our leaders react. So it's all up in the air right now. I don't know. All right. I gotta find this song. I'm just gonna find this song. Oh God, I'm glad I'm not sharing. Jesus, holy fuck. No. Oh man, I am. You guys have no idea. You guys have no idea what that was just now. You have no idea what I just saw. I am so glad I wasn't sharing that screen. That's why I said you can't share X. You just can't share X. You can't. You can't share. You can't share X. Except for exactly what you're sharing. Because if I had to share that, man, my channel would have been gone. It had probably been gone immediately. Then it'd have been like, nope, you get nothing. You don't get to go. You don't get to play in YouTube anymore. Dang it, man. I wish X would freaking... Elon, if you're listening to this, which I know you're not, but fix your freaking search, man. It is the worst. Oh yeah, no, they do. They have all their hands in Africa, in Europe, in Asia, in just yes. I wish I would have remembered to freaking mark that today because it was so damn funny. It was really funny. I'm gonna try. I'm gonna keep trying here. Hang on a second. Bear with me. Bear with me while we can talk about this other stuff. Yeah, I mean they do. China is definitely spread throughout the world, doing everything they can to, they've got their loan program and everything. And so oh man. Gotta find it, guys. You will love it. Okay, I can't show that one though. That's funny. That's an AI Judd Welcher. Okay. Oh man. All right. I guess I'll try and find. Oh wait. No. I'm gonna keep trying. Give me just another minute. Another minute, and then I'll give up. Nope. I laughed and I should have saved it immediately. I should have. It's just, you can't search by like a concept, right? It's you have to search for words that are in things. And then it's like, so I search for Judd Welcher and I get all this stuff from Judd Welcher. Then I put Judd Welcher song. Nothing in any of these things has Judd Welcher in it. It's all just random shit from, 2024. It's like, what the? It really sucks. I really wish they would have. It was basically when he does the whole spread your load thing, and it was just like over and over and over again with different speeds, and it was funny. All right, maybe I'll try and find it for tomorrow night. I will do my best. Okay, all right, let's get after it because, like I said, I'm already starting 35 minutes. We've been going 35 minutes in here already. Jesus. All right, we had a conference this morning. We'll speed this up to 1.5 and let's go. All right, so first off, the defense made I'm going to skip through this because the defense made a motion to dismiss the case, saying they didn't have enough evidence.
6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly,
so then Lally gets up and says,
testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave
didn't happen. And so then Bev said, whatever, I'll take it under advice. Or she said, no, I'm not going to do it. Okay. So then the Commonwealth, or then the defense was going to ask for, wanted to hear this
also.
So they wanted to ask for a missing witness instruction, which the missing witness instruction, as far as I understand, is the Bev can give an instruction that basically, because the prosecution did not call certain witnesses, then you can take that into account for your deliberation. So because, and especially for Proctor and Higgins and some of the main people in this thing, if they didn't call those witnesses, then you can take that into account in your deliberations. And so they have withdrawn that. So let's just watch.
Okay, the court denied that.
All right. So regarding the charge, so we'll start with the defendant's missing witness.
I wanted to hear this. Also, these motions they don't get so
Okay.
witness installed.
Go past this.
Oh, okay. So everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
with regard to the absent witness instruction, we're withdrawing that request.
Okay.
Why?
And what else from your?
Hey, what? All right. Well, the defense is withdrawing their request for missing witness instruction.
We're not going to, yeah.
Okay. I was actually really interested to hear the argument on that.
Right. And that's, I'm sure the defense was up late. Sure, they were up super late deciding, okay, what are we going after? What position, what is our best position that we have? Their best position, I think, is we'll hear about it later, the lack of a very rigorous investigation. That's the best thing that they have. So
You said there were two. What's the second
There's an entry on our request for lost or destroyed evidence. We're withdrawing that.
Okay, I had a question about that.
Well,
All right.
darn it.
Thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of this sweatshirt.
Oh, that's right. You filed. I saw it in email. I don't have a hard copy of it.
That's Mr. Lessman.
Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it. Okay. Who's arguing?
So the defense has withdrawn their missing witness instruction request. The defense is still making a request for an additional instruction regarding the hoodie, and we are going to get into the rest of the charge conference. So they are going to talk probably pretty quickly with the numbers of the jury instruction, etc. Interesting.
For the rest of the defendant's proposed instructions. Okay, so we're going to go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right? All right, so model homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the question related to murder charge, Commonwealth is only seeking instruction on.
I do think it's interesting that we get Lally today. Brennan has been yakking and yakking and yakking for weeks. Lally's done a few witnesses, but for the most part, it's just been Brennan. But today, for the charge conference, we get Lally.
All right, so we'll deal with that. I'm going to go through the defendant's instructions, or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction to propose on page 4, reaching a verdict. I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal.
Oh, so we're going to talk about that, are we? I think it was clear, and I was upheld on that. The individual indictment instruction is talking about making a verdict or finding a verdict on each individual indictment. I think it was clear. I think we can make it more clear, though. I think we can make it more clear.
Yeah, so what she's talking about where she was upheld is that basically last year when certain jurors came out and said we were unanimous that there was no, I know, I love her. Like, we were unanimous that murder was, she didn't commit murder, right? And then what Bev was saying, well, they upheld me when you guys appealed that. Well, kinda, but they did, they kind of, from what I read earlier, they made another argument basically in the thing that, maybe she wasn't on the best territory. So I don't know.
So that's the instruction they're talking about now, about finding a verdict on each individual indictment. I was upheld on that. Okay.
Clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Mr. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction? Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give.
So they're going to give a instruction that just because the defendant didn't testify, you can't have any inference from that. So
I will give you Bowden.
All right. So this is a big part. This right here is going to be an argument this is what the defense is going to come down to, is their Bowden argument. The argument that there were other suspects. There were other sources that the police could have investigated in this and not focused just on Karen Reed. And they failed to do that. So,
okay, I'm going to take a look at what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instructions.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to...
The Commonwealth is now arguing the Bowden instruction. A lot of the instructions...
Yeah. So the Commonwealth's going to argue against the Bowden instruction. Of course they
are standard. When it comes to things like the Bowden instruction, it is not a standard instruction. It's an instruction that needs to be requested. The Commonwealth is objecting. The court's going to give it either way. The Bowden instruction is an instruction regarding the sufficiency of the police investigation. So that's what the instruction is regarding. I'm interested to hear what Lally's argument of it is. I'm surprised that he's the one arguing these and not Brennan. Maybe Brennan's sitting in court working on closing and Lally's arguing this all today, but okay. So on the Bowden instruction, it covers sufficiency of the investigation. The defense has requested it. The Commonwealth is objecting to it. So Lally's going to argue that.
The Bowden, and I would incorporate, I know there's a request for instruction for third-party culprit, but the Commonwealth will be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden? You don't think the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either or third party culprit in this trial has come from questions from the defense.
Lally, the court specifically just asked you about Bowden, and you're arguing third-party culpability and third-party culprit. Those aren't the same thing, my guy. Can you answer the Bowden question first and then hop over to the other topic?
Yeah, exactly.
Just conflating the two of them? Okay.
From actual evidence in case, testimony from witnesses from the stand. See, it says what is evidence or anything of the like. So in the instruction and arguments are based or predicated based on evidence. And obviously, if we're well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually being evidence in this case. There is no basis whatsoever for not only both or third party instruction, but specifically for even counsel to make that argument during the course of the book. And I understand Bowden is a little bit more loose.
There's a microphone. And later on in this damn thing, finally, at the end, they push the microphone over in front of him. Right here, where my mouse is. That is a microphone. So all he's got to do is lean his microphone over this way, and you could freaking hear him.
As far as we're certainly...
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Mr. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material.
She's going to allow them to do that.
The chain of custody was contaminated and corrupted. There was evidence of bias. The lead investigator failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a boss of the cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lally's comments about how being introduced affirmative evidence of the proper way to do an investigation. We tried, Your Honor.
This argument makes me so mad. It makes me so mad. They didn't put forth any affirmative evidence, right? Because the court wouldn't let them. The court wouldn't let them. They asked to bring in a police procedure expert, and the court said no.
Right, exactly.
Lally's like, well, they didn't put on this evidence. The fact that Yannetti's not screaming shows how early in the day it is and how restrained. Because good God, well, they didn't put on any affirmative evidence of that. They asked, and then they asked for reconsideration. The court was like, no, no, no. Oh my God. And Lally's like, stop it. They couldn't. She's going to let them have the Bowden instruction. And should.
We made a motion and renewed it, asking for reconsideration of the court.
If not, to just follow up what Emily just said there, if not, they're saying that the defense can't defend their client. Their defense has no defense. You get no defense. You get nothing. You don't get to argue anything. You might as well just let us do our closing, and then you get up there and say, well, she didn't do it. Okay, find her in, not guilty. It just doesn't work like that. It's not how any of this works.
Could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to...
I think what Mr. Lally was saying, that you asked questions but weren't given answers, and so I think that's what was said. I'm going to allow you to argue Bowden, and I am going to give an instruction. So third party culprit's an entirely different animal here. I know, but tell me, are you going to argue it?
She's like, are you going to get up there and argue about Higgins? And here's the fine line. Let's take a second. Here's the fine line between Bowden and third-party culprit. We are going to go over the necessary witness stuff as we get at the end of the charging conference. I see you guys. I'm not forgetting you. It's a longer conversation, and I want to watch the rest of the charging conference with you. But we will go over why the defense withdrew that to the best of our ability after we finish the charging conference. Bowden and third-party culprit are different but interrelated. The interrelatedness is that part of a Bowden argument, Bowden being a argument that the police didn't do necessary things. That includes following necessary leads. That means the defense should be able to argue, look at all this information about Higgins. He's texting Karen Reed. He's ghosted. Look at the video that night. He's texting John O'Keefe. Are you coming here? What are you doing this? What are you doing that? Not arguing that Higgins did something. Arguing that law enforcement should have looked into whether or not Higgins did something. The third party defense is did Higgins do it? Like Higgins did.
Right. The third party defense is taking the next step. The first step is the police didn't investigate. The investigation was not done properly. The next step, the second step, is the third party culprit, as this is who actually did it. And that was what, I mean, because of all the witnesses they had last year, that was a lot of how their case went down. That's a lot how the defense's case went down, because they basically played with what they were given, right? They were given all these witnesses. They were given all these witnesses that they could cross-examine, so they could make more of an argument that way. This year, they don't have those witnesses. Those witnesses did not come in. That stuff is not in evidence. So you can't really make you can't make as strong third-party defense argument, but you can make a good Bowden. They didn't follow up on an argument, and the science isn't there. It's going to be two things. One, the cops didn't investigate. And two, the cops should have investigated more, because the science said that this was not a collision. So,
that is the third party defense arguing Higgins did it. The Bowden defense is, look, law enforcement should have looked into this. Look at the video from the waterfall. Look at the video from Canton PD. Look at the fact that his car was there. Look at the text to Karen. Look at the text to John. Look at. The police should have looked at it. And they didn't follow logical and necessary leads and they did not do the investigation that they should do. That's the Bowden defense. The third party defense is arguing you have to find Karen Reed not guilty because this person is the person. The person is the culprit. Police should have looked at it more. And that's the Bowden defense. Leads versus is this alternate person the perpetrator? Does that, I hope, leads and
skip through.
And we're going to take a moment to thank them, because we need a moment to thank them, because A, our stream sponsors allow us to put less ads in stream. So Replay Crew, love you, always thinking of you guys. B, it makes sure that Team Baker gets well taken care of while we are in trial briefs. And because Team Baker can survive the rest of 2025 if Emily doesn't get to sleep while we're in trial. So a massive thank you to our sponsor today, Incogni. This is a service I use. Keeping yourself safe online. Let's continue on to court. The court is giving the Bowden instruction. Hopefully we now know the difference between Bowden and third party culprit. And the court's going to get into that conversation too.
Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you
I just ruled out Colin Albert from the get-go for, just because I need to protect him.
The opportunity to try and develop testimony regarding Brian Higgins and
I need to protect my Mick Alberts. Who's going to rent my summer cottage?
Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as third-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that, not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction you are, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
Yeah.
So Ms. Gianetti, and of course I take him at his word, tells me that they're not going to do.
It's a better argument for the defense, I think. Hey, look at all this stuff.
Old nephew.
And it wasn't investigated. It is I think, a stronger argument. I think it's a better argument. We knew the court was going to give the Bowden instruction. She's been on board with Bowden from the beginning. And the standard for the defense to meet for Bowden is much lower than the standard for third-party culprit. The third-party culprit is a much higher standard. I also think it feels like overreaching. And when the defense overreaches, the jury tends to tune out. I don't think it's overreaching to say, look at all this stuff with Brian Higgins. Why didn't you do more?
I think that Jackson can very much put together a very good closing tomorrow. I think, and it's funny because I was looking at it, and the defense goes first. It's the defense and then the prosecution. So the defense has got to hit it. I mean, they got to hit it so far out of the park that old Brennan doesn't have a chance to do anything. But I think they can. You talk about the evidence that you have that it wasn't a collision, that he didn't get hit by the car, that the scratches are dog bites, and the fact that the police did not investigate these other people, especially Brian Higgins. And I mean, I think you've got a strong. I almost wish that Hank would have brought Welcher back. I do. I actually wanted to see that after Rentschler's takedown of Welcher yesterday, where he slows down that thing and you see the elbow. We saw that the elbow moved. The car's backing up at 2 miles an hour and it's not going to hit the upper arm. The car's not going to hit the upper arm. So what's he do? He pushes his arm forward to get it to hit. I wanted to see Welcher back on the stand. I did. I wanted to see that. I wanted to see Alessi just take him apart. Kind of bummed we don't get that. But I think he would have been crushed. So, that's just my own selfish reasons for wanting to see Welcher come back and get crushed on the stand. That would have been awesome.
That is a completely fair argument. And I think a lot of people who might not be on board with these other people did a thing might be on board with, yeah, why didn't they investigate it more? Is it because they're all cops? Is that what it is? And if they didn't investigate it more, then how can we say for certain that the person sitting here in court is the person that did the thing? It is a good argument. It is a good argument for the defense. And I think it's easier for the jury to follow.
Pure third-party culprit. Okay, that's great. That makes that easier. So
They're
I
not
will
trying
give.
to.
Sure, go ahead.
While we're on page 8, I just wanted to almost have an objection to the piece of instruction at the top of the page.
God damn it. We have gone from Brennan screaming at everybody in court so that he can be heard to Lally speaking under his breath. I understand why Lally's not projecting because the court's literally like right there, but it is so hard to hear what he's saying. It's just Lally's objecting again. So. Okay.
Sure, go ahead.
While we're on page 8, I just wanted to almost have an objection to the piece of instruction at the top of page 8.
Yeah, I have a check mark next to that. Ms. Giannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest. But, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done. It wasn't done. We have a
Yeah, so this, and you'll hear Emily in a second, this is a weak argument. I don't think they're going to get this. Saying that she should have been recorded, the interview with her at her parents' house should have been recorded.
There was a possibility for a recording, so we still think we're entitled to.
Do you think it was custodial interrogation?
No.
Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was custodial.
Not a good one.
We had police officers who refused to sit down in the living room. They were surrounding her.
That is not your strongest argument.
Familiar with dealing with the police at all. So yes, I think there's an argument that could be considered.
Not a good argument.
All right, what do you say about all this, Mr. Hill?
And I would also add more.
Sure. That it's not custodial.
Around the same time. So that it goes to initial custody and.
Yeah, that one's a
of this. So the juror spoke to Ms. Reed out of context, as they did the number of people while she was seated on the couch in her parents' living room, the parents were present, no one was restricted on the evening, and it did not end any sort of custodial situation. She was taken into custody, arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed over the course of the day, if I'm mistaken, from Ms. Reed herself. But the bigger issue that I have is placement, as far as there's already been in saying requested jury instructions or requested main practice, and then following the DGMP's language in the defendant's requested jury instructions, there goes on to all of his other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context with main practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when.
So I think
the court asked Lally to finish his thoughts on the absence of recording argument, and he is now jumping into another topic, jumping into a situation, a custodial environment like parents' house. It was not a custodial interrogation. She was not in custody. They're going to moving on to argue about a few other things, which we will get to, I'm sure.
Sergeant Kennedy having testimony from Stan, and initially she said she wanted to be fine with answering questions if they wanted and when the questions became centered on, or more centered on people, at that point, I know that's not a jury, but of course, where she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think it rises to the level of the DGMP's instruction. So I would ask basically that everything on page 8 prior to the instruction be exercised.
I've tried to gain Lally up. He is hard to hear. And so now, because we've got it gained up to try to hear Lally, we hear the court reporter in the background as well. But no, Karen Reed was not arrested the 29th. And yes, they can seize property without taking her into custody. 100%.
I'll take another look at this and I'll just let you know in the morning.
With regard to the compromised mental.
That's why a lot of this is just, I mean, this is supposed to be a conference that you put all of these things to rest, right? But it's Bev. Bev cannot make a decision on the bench, ever. She can never make a real decision on the bet. The only time she will make a decision on the bench is when she's already made that decision, when she comes to the bench with a decision. I will say the Bowden instruction that they just argued about a few minutes ago. She already, and she said it at the beginning of the thing, I'm going to give a Bowden instruction, and made it so it sounded like you have to talk me out of giving this Bowden instruction. So I'm going to give it, but Lally, I will give you a chance to talk me out of it. So she'd already made a decision. She cannot make a decision on anything else. I mean, yeah, she got a decision allergy. That's exactly what she's got. She's got I can't make a decision allergy.
We believe that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
It's going to happen to happen once, not.
Yeah.
I think that's fair.
Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the drop that they saw on the view was not present on January 29th. We asked for it to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence you're withdrawing. Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it. Sure.
I mean, the law enforcement witness instruction should just go with the expert witness instruction. Why do you have them in such a weird order? Okay.
Okay.
That's what the police officer or someone else.
Did Lally say he's objecting to that?
Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it. Sure. Okay.
That's what the police officer or someone else works for a law enforcement agency.
What do you mean by that?
I think that was taken.
Police officer or someone else that works for a law enforcement agency?
Dispatcher, perhaps. We're not.
I'll do police officer because they're police testimony. I'm not going to go beyond that. Okay, thank you. I'll do.
Lally objected to some of the language in that instruction, and Yannetti said we can modify it to just this, and the court said that's what I'm going to do. So we will hear that full instruction tomorrow. It's just about not giving law enforcement officers undue weight just because of their job.
The photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I'll cover all those topics.
What do you mean you're not going to give exactly this? Give them the language of the jury instructions because they're going to use it in closing. When are you going to give them the edited version then?
Tomorrow. She's going to give them the edited version right before they have to get up and give their closing arguments. It's so ridiculous. It's so ridiculous. This is supposed to be the conference to get this stuff figured out. This is not supposed to be the conference that I will take everything under advisement and let you know tomorrow, minutes before your closing.
Okay.
I'm suggesting there was indicates photographs and evidence.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think that Francis introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so...
The SJC is the Supreme Judicial Court. They oversee a lot of the writing of the jury instructions, so it's going to be verbatim. Most of the general instructions should be verbatim, just exactly what's written in the model instructions with relatively few modifications.
The Commonwealth's
What?
Requests are sort of in the you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to your.
Oh, this will be interesting. Let's talk about the law.
It's not numbered. Your supplemental instructions, use of a dangerous weapon.
Yes.
All right, so I'm going to give that, Mr. Yannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Yes, cars count as a dangerous weapon. Yes, that's standard in all jurisdictions if there is a weapon involved. I've seen dangerous weapon instructions on skateboards, baseball bats. If there was an...
I'm going to give what is not evidence. Evaluating the evidence, there's some instruction.
Right, so...
Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something preface it, witnesses, when, the attorneys interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during.
Are you going to tell them that it's okay to eat lunch? I'm just curious. I'm being snarky. That's not going to go in there.
Trial. During the course of the trial. I'll just say we're preparing.
There wasn't a sequestration before the trial, so what is she talking about? See, she's an idiot. This person is an idiot. That shouldn't even come up. They were allowed to interview their witnesses. So if there was a sequestration trial, then every witness that Jen McCabe met with them 5 times. Kerry Roberts met with them 5 or 6 times. All these people that said they met with them multiple times, that should not have been allowed.
Yep.
We're joining in with, I don't know if we included that in our instruction, but we're joining in almost less for that.
All right.
I would just modify that line out then.
Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction.
That's not in evidence in this case. Why do you need a prior bad acts instruction?
Before that testimony came in, I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases. I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right. So
ridiculous.
So the court has said that Aruba was mentioned through John O'Keefe's niece in testimony. The defense withdrew their objection to it. The prior bad acts instruction is going to come in, and we will hear that instruction in full when they read it tomorrow, but it's regarding a confrontation in Aruba. So
did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. It might be covered enough when I give the electronic communications instruction. So I will think about that. All right. Those were the limiting instructions I wanted to get to. So
we would object to the part of that actually link to the beginning's text message.
All right. I'm going to take a look at that, Mr. Lessy. All right.
Did she just call you Nettie Alessi?
Okay. All right.
Huh.
All right.
The Commonwealth withdrew their consciousness of guilt instruction.
Oh, good.
Okay.
That's
the
because
Commonwealth had argued that removing the vehicle was consciousness of guilt. It wasn't a good argument, but that was their argument. When Karen drove the car from One Meadows back to her parents' house, that was her removing the murder weapon. I'm sure some of you remember those arguments. They're withdrawing that instruction, so it won't be given to the jury.
So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only...
1 second, let me just pull that up. Okay.
Your Honor, West clearly not for any change or alteration in instructions that were given other than there are 3 prongs of malice, essentially.
It's hard to
hear. Yes, he is miserably hard to hear. Miserably hard. It is so hard to hear. Appreciates it. We can't...
Okay.
The Commonwealth here, the first 2 prongs are essentially trained in this situation and
do you have supportive case law for me to single this out? What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do the Greeks while around non-intentional. In just the third prong, he stated that in his opening. I imagine that's what he'll likely argue in his closing. I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll refer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so. You're not closing. I don't have
I'm inclined to go with the model.
Why are we arguing over the model jury instruction for second degree? Like, why do we need to modify it? Just give the model instruction.
Right.
I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support.
The Commonwealth is asking to modify the instruction, and I think with the court, it's just give the model instruction. I hear that the prosecutor is asking to change it. The defense has...
Why is Bev offering to look up a case law for something the Commonwealth's requesting? What, she wouldn't do that for the defense. There's no way she would go and search for case law to give the defense, some ammo for their position. She wouldn't do that. So why would she do it for the Commonwealth?
Said they're not feeling strongly one way or the other, and then you go with the model instruction and you don't modify it. There has to be a second degree instruction. So just stick with the model instruction.
The position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really anyone who's good. I understand, and I don't...
I suppose I could always tell the jurors that...
And the defense is saying no. She's saying if both of you want it modified from the second degree, or the model jury instruction modified, it might be that there isn't its own second degree instruction, and that both parties are like, can we just narrow this down?
Yeah, maybe.
Why wouldn't you just have a second degree instruction? It's very confusing to modify a first degree instruction.
The judicial court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, okay, I'll let you know before we begin.
Well, that explains why. That explains why, because the SJC has modified the rules, and the SJC is like, you have to read them all. Well, that makes sense. If the SJC has modified the rules to say these have to be read, and then you have to read in the instruction and say, but those things don't apply, it gets...
Before the court makes a decision on that, we see what the court is proposing. If you are going to alter the...
If I alter it, it means I remove those two. That's all. Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want to know UI instruction? You were.
Which ones?
All right.
No one's going to the mic today. We'll talk about the prongs later. Don't worry, we'll talk about the prongs later. It'll come in more tomorrow because we're going to talk about shit today that's going to get modified before the jury hears it tomorrow because we're not going to have the final jury instructions, but through the charging. So they're done with charging through the
I think that's it, aside from Mr. Lessie's motion regarding the exhibit.
So they're done with charging.
Is there anything else that we're missing?
Just a couple of other issues. One is with regard to the doctor text messages, we have a redacted version now, which we'd like to submit to the court on the Commonwealth. You recall that we had agreed essentially on the redaction subject to the court's ruling,
okay,
but it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it. I'm going to give it to them now.
So those are the redacted text messages to substitute into evidence.
Sure, thank you.
Doctor's text messages.
All right, so hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So.
Commonwealth, you better agree.
I do not believe it's going to be a problem.
Okay.
Just a couple other things before we get to Mr. Leslie.
Yep.
One is that we do have the Dr. Wolf PowerPoint to be introduced in evidence on.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have to redact it. So we
okay.
Redact it. It's not on by that.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
Somebody's got to look at it.
Will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Oh, she is so generous. I'll give you an hour and 15.
All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor. If I didn't.
You did not.
I'm not surprised by that. Yannetti has a proposed verdict slip for count 2 that was also much discussed last trial because there was some confusion with it. So this is the verdict in fairly simple charging conference. So I know it being a foreign language because they're talking about this. They all understand what they're talking about. They did verdict form. All right, that's a modification.
All right. Oh, I digested it, Mr. Leslie. Go ahead, I'll hear you. Yannetti, jeez, I'm sorry.
So, Your Honor, you recall we had some spirited argument.
That's funny. I'm gonna back that up.
She's
She's just like, I'm Yannetti. She's like, oh my God, we're tired. We're tired. That's funny. Do you need time to digest it? No, I've digested it. This is argument on the verdict slip for count 2. Count 2 involves numerous lesser includeds. That can get confusing.
Oh, I digested it, Mr. Leslie. Go ahead, I'll hear you. Yannetti, jeez, I'm sorry.
So, Your Honor, you recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each.
The lesser included crimes all have subparts. Count 2 is a bit of a cluster because it's all very different. And then each lesser included has subparts to the lesser included. So it is not, of all of the things, count 2 and the verdict form for count 2 is not simple. However, I think part of that is on the attorneys to put count 2 up on the screen and walk the jury through the understanding. Because once you explain it, I think it becomes much more clear. Not explaining it is part of the problem.
Let this run.
With there being one option for not guilty at the top of the form, and then multiple.
But it was like not guilty to all.
Different types of guilty verdicts.
It was like not guilty, period.
So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict, the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the least, I should say, of the lesser included offenses is simple operating under the influence where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as a court trial, well aware of almost not requesting any lesser included, and I certainly understand that if the evidence supports the defense requested, that the court must give it.
What did you just say? 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 Did you just say the Commonwealth's not requesting any lesser includeds? What? Okay. Okay. I'm going to try to game this up again because that's what I think he said.
As a court trial, well aware of almost not requesting any lesser included, and I certainly understand that if
the Commonwealth is not requesting any lesser includeds. Okay.
Having said that, the verdict slip was used in this matter last year. Commonwealth Smith is more sufficient adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently while this case was going on, tried before Judge Lally, in which he had similar issues. I believe he was at least part of the verdict slip from the first trial, in this case, as sort of template for the lesser included that he instructed and verdict slip that he utilized in active. I don't have a copy of it on me, but I can certainly get a court copy of it. That may somewhat helpful with the court's opinion.
Okay, was that on murder case?
It was not. It had to do with...
Okay, so that is a cat question. That I don't know. As far as training stuff, yes. Let me see where my wife is, because that is 100% a cat question. I know in sheep, you can give them a combination of like yogurt and Guinness and other stuff. For dogs, I'm not sure. Let me just pop on the phone here with her real quick. Because that sounds ugly. Oh my gosh. Oh no. Oh no. Let me see. Let's see if she'll answer here real quick. Oh no! Oh my gosh! Yeah, she doesn't need that. Hey, honey, how are you? All right, I'm gonna mute for a second.
The felony will be a homicide.
Yeah, I'll take a look at it. Mr. Turk. Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lally is an excellent judge. We think that this verdict slip is.
She just left the store. So, she just left the store. She's heading home, and I'm sure her brain is already cranking. So she, like I said, we used to have sled dogs. Then we had, we had sled dogs before. Then we've had Australian Shepherds now for, Vader. My buddy Vader is 15. And then his parents we had before him. And so they've already passed on. We've had dogs for a long, long time. And so she said, she's going to think about it. And she's got books somewhere around here too. So we will definitely find something. So, I feel that's awful. Oh my gosh, those poor guys. All right. So we'll find something. So just, out. Like I said, she's about 10 minutes away, and then we'll see what we can get started. So, all right. Yeah. Do you know what kind? What was it? Ugh. All right. Let's go back to this. So basically, what they're saying here is there's going to be no lesser included. So on that count 2, you're not going to have the And let me see if I can find. Karen, read, jury, slip, and you'll see we can find it here. This was count 2 last year. So you had manslaughter while operating a motor vehicle under the influence. And then we had not guilty or guilty as offense charged. And then all this other stuff. And I think this was the original one. Actually, looking at it, this was the original one. So give me a second. That was the original one that was way confusing. And then they put guilty on the other one, on it, like somewhere. Let's see. Damn it. X in there. Read it. Jury slip. Images. Oh no, a moth. Ah. Ugh. Yeah, Chew. I've heard good things about Chewy, and I'm glad they stepped up. We can't. I've tried to buy stuff from Chewy, and then I get to the checkout, and it's like, no, we don't ship to Alaska. So it's like, I'm not finding it. But anyway, so last year the verdict slip was really stupid. It was hard to understand. They came back. They did eventually modify it, but still not enough. And so, but if they're not going to have the lesser includeds, then I think they're okay. So that would be good. Oh, damn it. Oh, it sucks. I'm so sorry. Well, let's talk about this for a little bit. Let Kat dig in there and find something here. All right. Where are we? Right back. I don't know. Yeah, that's weird. I don't know. I don't know why. Hmm, that's a tough one. I mean, obviously you do want to give the jury a way to compromise and say, okay, this is something. And I think they argue here. Let's listen to them a little bit. Let's see what they argue for. No, I hear you. Oh yeah, I mean, I'm an idiot.
Though there's not going to be a consciousness of guilt instruction, that they be allowed to argue to the jury. The Karen Reed statement about Jen McCabe, it's her or me, and taking the vehicle is
Listening
consciousness of guilt.
Okay, back a little bit.
Would be the one where essentially she says it's to her supervised residence indictment, and then certain statements made in reference the various clips of her statements in particular would be the one where essentially she says it's to her.
All right. Ms. Giannetti, do you want to weigh in on that?
Yes, to that. I don't see it's her or me being conscious of guilt. And the notion that
So they're trying to get that consciousness of guilt thing back in there, saying that she drove the car from one place to another as conscious of guilt. That's
she's driving from one residence that police know of.
Lally is arguing that even though there's not going to be a consciousness of guilt instruction, that they be allowed to argue to the jury that Karen Reed's statement about Jen McCabe, it's her or me, and taking the vehicle is consciousness of guilt. The defense is objecting.
To another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness.
Okay, because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
That's fair.
And just to be further.
So she's going to let him argue it. She's just not going to give the consciousness of guilt instruction. Oh my gosh, yes. Turtleboy was not guilty today. We'll go over that here in a bit.
Yes, so I did want to ask you, though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well? Okay. Okay, I just wanted to give you...
Do not do a consciousness of guilt instruction at all.
So the court said, I was not going to give this instruction at the Commonwealth's request, but if the defense requested, I will give it. And the defense is like, no, we do not want the consciousness of guilt instruction, even if they're allowed to argue the inference, they're not giving the instruction.
The opportunity. Okay.
Oh, I know.
Anything else?
Yeah, he's still not out of the wood at all.
We're going to hear from Mr. Alessi, but... That's great. Thank you.
And Ms. McLaughlin chimed in and said the Commonwealth has no objections to the redactions to the text messages, so those won't be discussed tomorrow. Those will just get substituted in.
Last thing you all have to do today, okay?
I think Kim picking a bench trial for this one instead of a jury trial is different. Now, if they go forward with these other ones, I think a jury trial is probably a better option for the other trial. But I think bench trial in this one was a good call.
I know. Right, so let's make that. Are we switching?
They are, man.
That new redacted version with an exhibit number. Do we know what it was?
Oh my God, the sound.
Excuse me. The redactions on the Higgins.
It seems like the court can't hear them either with the way she's leaning forward.
Messages. That's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications. Okay.
This is testimony that came in.
Of Proctor. Yes. All right. So we'll find the exhibit number and we'll just. 209. Is everybody in agreement that it's exhibit 209?
They're going to need to go through the notes.
Okay.
Court have a copy, or do they need to come up?
Yeah.
So it'll be marked MMM for ID.
That's great.
And then the redacted version will now testify.
209. Yep.
No.
Okay.
Because then there's numbers. Is what they call it when they send to the jury, and there's a set of instructions they get before closing argument, and then after. You, Madam Court Reporter, just a win. Just a win. Just an absolute win.
Okay.
Pushing this. No. Because then there's numbers. Into the marked exhibit.
I might suggest, respectfully, a procedure to the court. I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps...
He did, right now.
I can actually hear him, but he was peaking a little bit, so I'm going to see if I can continue to modify the sound, but I can hear him pretty well. So, we'll see how it goes.
He's 100% right. This is 100% right. And oh, she makes me so mad here in a bit. I'll show you. She just makes me so mad. Yeah.
If I might suggest to Your Honor to avoid a more lengthier argument, you might even truncate it down to 30 seconds. If you hear from the motion or curative instruction regarding Exhibit 88 and introduction into evidence of exhibits, the exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
The Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction.
Well, God damn it. Now we just can't hear. We're going to have to deal with the peaking, or we won't be able to hear the Commonwealth's argument at all.
What's the Commonwealth's position?
The Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction to give in final charge. The Commonwealth will submit that the contemporaneous instruction is more than sufficient for resolution, and that it doesn't
Lally said the instruction the court gave to the jury at the time is sufficient, so they don't need another one.
require any sort of differing language or further instruction given to the jury during the court final charge.
Okay. All right, I'll hear you, Mr. Alessi.
May I go to the podium?
Yes.
Thank you.
Please go to the podium.
Yep. And follow me on X too,
The
KDK.
Commonwealth has mildly objected. Like, most mildly objected. Like, we submit it's fine. It is not a strenuous objection. It is a, we object.
Your Honor, I have given, and Your Honor provided me previously with the
X has got really good DMs. So yeah, if you follow Patty, and then Pretty sure I found you on X, maybe.
On this, but I do need to cover.
And, I will put the. Let's see if I can put the link to my channel right here. I bet you I can. Hang on. There we go. Okay, it's coming up on. There we go.
At some points with regard to the matter, I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why did we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly.
It sounds like they just turned the microphones at the podium back on. Well, thank goodness for that.
But I think this.
We've gone the entire charging conference, and all of a sudden, the mics in the courtroom are turned on. Thank you, pool provider, for turning them on finally, so they don't have to be gained up. Good Lord.
Allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led
the holes where, Mr. Alessi? Here.
To a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted.
So we're coming up here on something, and I I have a feeling I know what Bev is going to say, but
and I think we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that's.
Sir, I appreciate you getting to the exact language, but we're just going to have sound issues today.
Starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Does YouTube
Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then it was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened.
100% did that. 100% did that. He started to say, well, I know that there had been cuttings too. Cuttings from the lab. That's not unusual that the lab takes cuttings of material. And so Alessi's laying it out even more for the court. Look, the witness was starting to answer that way and then was cut off.
Yep.
So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January.
There was some kind of larva in the food that she had. Probably either like a moth larva or let's see, what to do.
Was it hairy?
Was it hairy? I don't know.
Like, did it look like a little hairy caterpillar? Half an inch?
Did it look like a little half-inch hairy caterpillar? Let's see. You gotta give it a second because YouTube's got to catch up. So
February 29.
I believe so. Yeah, it was Science Diet prescription. Mm-hmm. So yeah, it would have been dry kibble. So
Okay.
see, fuzzy question again. Oh, maybe she answered that already.
Most common
think
thing
so.
I've found in dog food is larder beetle. Larder beetle larvas. They're kind of fuzzy. They're about yay long, and then they turn into little beetles that are black and brown. And once you have them, you're not getting rid of them.
2022 from a fall backwards.
But the white it was white. They were like white wormy things.
Are they fuzzy or not?
I don't know.
White wormy could also be fly larvas.
Mm-hmm.
Oh, they get a picture of it.
It's gone. It's been tossed. So.
Oh, okay.
But
the chickens would have loved it.
And moss flying all over too. So it actually produced some moths, I guess. So.
Okay.
So what? I mean,
Store-bought
she's
food.
making some chicken and rice and kale and. And something else. Carrots. So.
Yep. No, that's perfect.
So they were white worm looking. That was probably the meal moth, not the. Oh, that's Patty. Yeah. I mean, anything else? Like, is there any kind of over the counter? I mean, what can you give a dog that's sick? And you can't really give them.
So what are the symptoms of the being sick?
Puking and crapping. Diarrhea and puking.
And how old is the dog?
There's multiples. There's like and pumpkin. Anywhere from 12 down. One of them is 12, I guess. Everybody thinks it's the time to run here. Yes, 12 years. Yes. Yeah, I don't think I think they're all adults.
Had a lot of rain lately, right?
I don't know. Have you had a lot of rain lately? Why would that make a difference?
That could mean.
Oh, okay.
And
Okay.
but Giardia takes a prescription.
Giardia, if it's 2 9-year-olds.
Yeah. All having it, then yeah. I would take one stool.
Yeah, no, you could do that. Yeah, do one stool sample to the vet and see where you're at. Because if they've all got the same thing, then that's a good idea. And so instead of doing all of them, just take one, get one. It sounds like you've got plenty to sample from. Sorry, it's a bad joke. And if hopefully your vet would do that, would run a test on one sample.
No blood in the stool, right?
Yeah. Is there any blood? Is there any blood, or is it just the? Oh, gotcha. A duck trolling retriever, an Irish setter mix, and 2 spaniels. So yeah, have you seen any blood in the
And they are current on their parvo shot.
and current on parvo? Science diet was on the list causing issue. Oh, Patty was saying, yeah, there's a science diet was on the list causing issues because of mold and fungus being in the kibble.
Well, now
So,
that would do it too. But yeah, so easy on stuff. Pumpkin, the canned pumpkin.
Yeah, Cat's saying the canned pumpkin can kind of help. And then, yeah, you're on the right track with the rice and the chicken and
Just have one sample.
okay. Yeah, because if it's a bug, then they can get it. But yeah, like I said, just take one sample into the vet and have them test it and see what it comes back to, and then hopefully it'll level out over the next few days. Hopefully that getting over it, because if it is a parasite, then yeah. I guess getting that tested. Okay. Yep. We will talk some more. We're going to talk some more Karen Reed here now.
Go for it.
But yeah, it sounds like you're, on the right track. And if you can like I said, get one test done to figure out what it is.
Yep.
Vet AM 3 turds ready for sampling. Nope. Yeah. Oh yeah. No, I think she's got it. All right, Alessi arguing for the.
Struck you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police. I've got the acronym MSP Crime Lab. In the course of her inspection and sampling of the clothing on May 18, 2023, Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction.
Tupperware is pretty cheap. Yeah. I have a funny story about Tupperware. I was in a band for like 20 years, and our lead singer was a goofball, absolute goofball. And we had a song called I Sell Tupperware. I'll play it for you guys one of these days. But yeah, we had a lot of fun.
Your Honor had given, which was a sentence.
The court might give the bulk of that. The falsely insinuating part is not going to happen. But the rest of it is not highlighting the issue while still discussing the issue. And the jury can decide if it was a false insinuation. But
our band name was Whooped. And we came up with that because we were 4 married guys at the time. So that was what we settled on, and we did it.
Brennan asked about holes in the back of the sweatshirt, and it is known by all parties. I think would be appropriate. It's known by all parties that these holes were caused by the crime lab. That says it without saying it. The court's not going to say that one lawyer falsely insinuated something.
Thank you, City of Anchorage.
Tell the jury that they knew and asked about the questions.
Yeah,
I don't think falsely insinuate's going to get in there at all.
So, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the?
So here's where Canoni thinks she's going to get out of this. And from what I remember, when she gave that instruction, she did say the date. That's funny. I love it. So I think she did say that Marie Hart that made those holes on May 18th, right?
The date you requested, the May 18th date? I thought I did.
Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors.
That's what Canoni's going to get. She is an idiot. This woman is an idiot. She can't remember 4 or 5 things. She can't remember say that, Brennan did this, right? She didn't say anything about Brennan did this. All right. We need to go back. We need to go back to yesterday. Yeah, I know. I think you're right. I think she drinks on the damn job. I do. All right, we need to go back to the day of that testimony. And let's see. I'm curious. We're gonna have to go find it. So when was he on the stand? Let's see. So that's day 29. So I think day 30 should have been Dr. Wolf, right? No. Wait. Dr. Wolf was before. Yes. I'm remembering it now. Okay. Here we are. It might have been day 29. Oh, thank you. Might have been day 29 early.
Very
So I want to know exactly what she said. All right. Judge is ruling.
Session.
Appreciate your patience, Mr. Leslie. Why don't
Yeah.
you hold the exhibit up for the jurors,
Yeah.
please? All right, jurors.
So she even said earlier, I'm going to make this statement about all the stuff. You remember all the stuff she said she was going to put in her statement. Actually, let's go back to the
Going to put
rule.
in what's been marked for identification, YZ, instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022.
She said she was going to say all of that.
I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Leslie, what day these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates.
Your Honor, on or about May 18th, when the defense filed a motion to test. So that's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's 2023.
Yep.
Okay.
Session.
Patience, Mr. Leslie, why don't you hold the exhibit? The back of the sweatshirt. All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf.
That's the sweatshirt. Nothing about Brennan showed him the stuff. She does not mention Brennan's name at all.
Okay. Thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think Mr. Yannetti, your next.
I mean, that was ouch. That was so. I mean, that was not anything that she even came close to sounding like what she said she was going to say.
The date was important.
It's May 18th, right?
Yes, Your Honor. And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant...
Excuse me, Alessi, you're only allowed to say what with emphasis. It has to be what happened in this courtroom because you have now trained us to expect that you're going to say what that way every single time. Please. Thank you.
Topic, accident reconstruction.
I've seen that that Alessi and the Watt thing. I don't know if you guys have seen this. Let's see if this... So, the moment my kids found out that McDonald's chicken nugget meal actually comes with 6 nuggets, not 5.
What could be more egregious? What could be more misleading than that? And what could be more important? What could...
What? Oh, man. All right, let me hide that just to make sure we don't see something that we don't need to see. Oh my gosh. I love it. What? So many fun things in this crazy trial. All right.
Piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle. These cuts.
I love Alessi. He is long-winded. He will get on tears and he says, I'll be brief. And then he talks for, 5 minutes. And so, but the guy is thorough. The guy is old school. The guy is like, so, okay. So
the court is so close.
During the heat of trial, during the heat of the extended exchange with the witness on the stand, things can happen. States can be recognized, acknowledged, and...
Oh, court reporter for the fucking win. Thank you, Madam Court Reporter. Just
finally, at the
win.
End of the
Just
day,
a win. Just an absolute
over to
win.
him.
Pushing
on.
the microphone over at Lally's face. Just thank you.
God.
Now, why is Brendan not arguing this? I have no idea. Is he working on his closing? I don't know. But now we finally can hear Lally a bit better. Thanks to the court reporter for saving the day.
Accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence.
The stipulation's not sufficient, Lally. All right, I'm just backing up that argument.
So just, Katie, if you saw the group text chat on X, take a peek there because we set up a group message chat thing.
And accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been...
They didn't get it, though. They didn't get any kind of...
Many, many instances of similar type conduct that didn't result in a curative instruction. And to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time as far as whether it's from the testimony from the witness or the...
So, this is why Brendan should be arguing this. Lally is trying to argue it, and Lally's just like, statements?
Question from counsel was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay?
Thank you, Your Honor.
All right.
So Lally just argued that, well, the defense has done other things similar. The defense has done nothing similar to that. That's bull crap.
Anything else? Two things I'd like to talk about for scheduling.
All right, so tomorrow, 8:45, they'll be in the room.
I'll be in the courtroom at 8:45. While generally that will assure us the closing arguments will start right at 9. Maybe.
So she's going to give them the final jury instructions tomorrow. Actually, hopefully she gives them to them before their closing arguments, but who knows with her? She might wait until after the closing arguments and throw some crazy thing in there. Oh my gosh. No, I hear you. It's the stressful times like that. Yeah, you think, oh my God, what if I just started heroin? Yeah.
Maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask the counsel.
All right. So, yep. So they're going to give them to jury. We're going to jury tomorrow. All right. 8:30. That's 4:30 my time. They're going to start at 5 a.m. So I'm going to have to watch the closing arguments on repeat because I will not. I mean, we'll see. I mean, sometimes I get up at 5, but I don't know. We'll see. All right. I wanted to get to this. Maybe we'll do this tomorrow since we got or Monday or whatever. This is Billy Bush, and this is an interview with
courthouse today.
a retired Canton PD sergeant.
You get what you pay for on both.
I wanted to do this.
Peter Murphy. He served the Canton Mass PD for 30 years. He knows the.
So we will go over this. No, I know. No, I knew you were kidding. I don't know if you got some rum or something there. Maybe you dig into that. So yeah, I want to look at this. I want to go over this interview. This looks pretty interesting. This is a former Canton. No, I gotta go to work. Unfortunately, I wish I could stream this. I'm trying. We're building up one at a time. So, no, I will be. It will be 4:45 my time. 5 a.m. You don't want to see me at 5. Nobody wants to see me at 5 a.m. Cat doesn't want to see me at 5 a.m. Okay, we got one more thing tonight. Just go for it. Just go straight to the big time. All right. This is like a 11-minute thing. We'll skip through this a little bit here. So this was Nick Ricada today. Patty sent me this. This is great. So this is a song. So this is a grok song created by AI.
Transcript of text messages between Karen Reed and Brian Higgins. Please scan all of the messages.
No, I don't even drink anymore. I don't do hardly anything anymore. I'm a good guy now.
Come from Karen Reed. Consequently,
I had a lot of
denoted
everybody's drinks in the past.
B are from Brian Higgins. Please.
Yeah, sure. That's my
song in the style
of
an early 2000s emo band. The main narrator of the song should be Brian Higgins. However, Karen Reed could come in for some banger harmonies. Please focus the chorus around.
Great. So he's saying take the text messages between Karen Reed and Brian Higgins and create a song using those. Oh, cool. Oh, nice. Oh, that's awesome. Yeah, I want to watch that. So, but yeah, so take the text between Karen and Brian, make a song out of it based on 80s or was it early 2000s emo style. And
how much fun Brian Higgins is as per his text
will
messages. The verses should express consummate
lyrics.
Levels of insecurity and doubt, and the bridge should crescendo hard into his signature expression. I'll give you all the beach life you can handle. Please use use
life
full messages whenever possible. Full messages from Brian Higgins whenever possible. This has got to be a good enough prompt, right? Like this has to do it. Include a Boston accent. Well, we got to move it to another. This will just write the lyrics, and then we'll have to take those lyrics and put them into a different AI to actually compose the music and play it. Below is a song crafted in the style of an early 2000s emo band. Think Dashboard Confessional or Taking Back Sunday. With Brian Higgins as the main narrator and Karen Reed joining for harmonies in the chorus. The song is centered on the line. I'll give you all the beach life you can handle. I've incorporated full messages from Brian where possible, staying true to the emotional tone.
All right, here we go. Here's the.
So we got introspective, minor chords, and soft strumming. I'm staring at my phone. The screen's a silent scream. Did I come on too strong? I'm tearing at the seam. My words, they spill like ink. Hey, I'm a lot of fun. But doubt's a heavy anchor pulling me undone. She's out there in the night with someone else. I bet I'm not too serious. I type, but I'm a nervous wreck. Oh no.
My God, this is funny.
So we have a pre-chorus. Every K she reply cuts like a every K she M reply. I don't know what that is. Cuts like a blade. Is she laughing at my name? I'm drowning in the maybe, choking on the shame. I'm a lot of fun. I swear I'm the life of the scene. Super fun. Come hang out.
This song is so emo too.
Dream. Karen's voice lifts me up. Her harmony's my spark. We're burning bright. We're infinite, igniting in the dark. I'm gonna get this made into a karaoke track. We're gonna do this.
I definitely will.
I'm kind of bummed you didn't say hi. I sent at 2 a.m. My heart's a fragile fault line cracking where I stand. She says I'm busy, B, and I'm a ghost again. Should I take it easy? I'm spiraling within. Is she out with him tonight? Did I misread the vibe? I'm not that serious. I lied to keep my hope alive. Every K replies a rope.
Every K replies a rope.
But spraying at the ends. Am I the joke she's telling to her better friends? I'm a lot of fun, I swear. I'm alive in the scene. Super fun. Can hang out. I'm living the dream. Karen's voice, it pulls me through. Her harmony's my fight. We're screaming loud. We're breaking free. We're stars against the night. I'll give you all the beach life you can handle. Sand and waves. My heart's unraveling. I'm gambling. I'll give you all the beach life you can take. Every doubt, I burn it down for you. I'll break. Karen harmonizes beach life. Take it all away. I'm screaming till my voice gives out. I'm begging you to stay. I'm a lot of fun. I swear I'm the life of the scene. Super fun. Come hang out. I'm chasing every dream. Karen's voice holds me closer. Harmony's my home. We're endless, but I'm terrified. I'm singing this alone. Hey, you're free tonight. I text, but the silence stings. I'm a lot of fun. I swear, but doubt's a heavy thing. I'll give you all the beach life. I whisper to the dark. Karen, are you out there? You're the fire to my spark. I love this.
All right, so let's go ahead. Let's see if we can get to. So which version do you want? Do we want the peppy version, or do we want the? I don't want the peppy version. Let's see.
This song's. I'm not that serious. Like.
Is there multiple versions, or does he just get one version of it? I can't remember.
I like the song.
Everything, I'll give you all the.
So fucking cool. Oh damn.
Was it just one? Okay.
Oh, we gotta get.
Here we go.
Oh, I like that.
I'm staring at my phone, the screen's a silent scream. Did I come on too strong? I'm tearing at the seam. My words, they spill like ink. Hey, I'm a lot of fun, but doubt's a heavy anchor pulling me undone. She's out there in the
Oh, we gotta get this into a karaoke track. I already love it.
Someone else, I bet. I'm not too serious, I type, but I'm a nervous wreck. Every okay, she replied, cuts like a blade. Is she laughing at my name? I'm drowning in the maybe, choking on the shame. I'm a lot of fun, I swear. I'm the life of the scene. Super fun, come hang out. I'm living a dream. Karen's voice lifts me up.
This is horrible.
We're burning bright. We're infinite, igniting in the dark.
This.
Oh my good Lord. Being someone that has played music since I was a child. I started in the band in 5th grade playing the saxophone, and I've played many different. I played instruments all through high school, and then I switched to drums, and I played drums for basically my entire adult life. So I bet you he does. I bet you could probably find some through him. But so I have, I guess, just looking at AI music and how AI can just throw together a song like this. I mean, yeah, it's, I just have mixed feelings about this because there is something about that. Yeah. Is this the Tupperware song? No, this is not the Tupperware song. Far from it. But there's something about, the human, like, okay, great. There's a computer that can put the melodies together and put the lyrics together. And for something like this, it's quick and throwing it together and everything is great. But for like actually, art that is supposed to create emotions, because there's a lot of emotions tied to music. Everybody's got favorite songs, and this song, I remember this song when I was here, having an actual person behind the creation of that just feels a little better than a computer decided that it wanted to have some great thing. No, that is not the Tupperware song. So yeah, I don't know. You're not going to stop it. You're not going to stop progress. We're not going to stop AI music. And like there's lots of streamers now that just use it all the time, and people online. So it's not going to go away. So, what do you do? Where is my Google Drive? See if I can find. All right, let's go back to this. I'll get the Google Drive downloaded here. Give me a second. But let's finish the song here.
I'm kind of bummed you didn't say hi. I sent it 2 a.m. My heart's a fragile fault line cracking where I stand. She says I'm busy bee, and I'm a ghost again. Should I take it easy? I'm spiraling with
wow.
Sweet.
Oh wow.
Did I misread the vibe? I'm not that serious. I like keep my hope alive. Every okay replies a rope, but it's fraying at the ends. Am I the joke she's telling to her better friends? I'm a lot of fun, I swear. I'm the life of the scene. Super fun, come hang out, living a dream. Karen's voice, it pulls me through. Her harmony's my fight. We're screaming loud, we're breaking free. We're stars against the night. I'll give you all the bass life you can
Yeah, exactly. There's a love-hate. This is great. This is great, though.
Take it all away. I'm screaming till my voice gives out. I'm begging you to stay.
Oh, damn.
I'm a lot of fun, I swear. I'm the life of the scene. Super fun, come hang out. I'm chasing every dream. Karen's voice, it holds me closer. Harmony's my home. We're endless, but I'm terrified. I'm singing this alone.
This song is so fucking cool.
That was great.
Hey, freedom not a text, but the silence stings. I'm a lot of fun, I swear, but doubt's a heavy thing. I'll give you all the beach life, I whisper to the dark. Karen, are you out there? You're the fire to my spark.
No. I like the song. That's dumb. That's not even funny. Now we need to get this made into a karaoke.
All right, so this
the AI will do that, right? The AI can do everything.
Here to stop this. Stop the share. Share this. Okay, so by popular demand, All right. So this was a live recording from 2005. This is so. I don't know if you guys can hear this or not. Let me know if it's not loud enough. I'll try and crank it up a little bit. Oh, yeah, yes, this. This was a live recording. No, Nick is hilarious.
I'm not hearing anything.
Oh, wait, what? Oh, it's not playing? Not playing? Oh, wait, what? It's not playing? Damn it. I said share the screen and share the audio. Okay, give me a second. Sorry, guys. Damn it. Okay, yep. Oh, I'm on it. I'm working on it. Window will not let me share that. So the entire screen, turn on that, share that. Oh, maybe did I share the other thing? Okay, let's try that again. Okay, hang right there so I can hear this. All right, let's see. Nope. Gosh darn it. Okay, so how do I do this? Because I had to it's on my other Google Drive. So okay, Dang it, why is it not sharing my audio? Oh, I know. Hang on. Okay, hang on. Okay. Give this one more try. Let me go ahead and put my earplug in. Yep, I know. I figured I know why. Okay. This should work.
Are those
Maybe.
real? Or are those plastic? Tupperware.
There it is. Yep. That's it. This was live. Oh, I'm sorry.
You think a good man, if you don't mind, would you pop the car? There's a good fellow. If that's all right with you. Oh, you are quite correct. I was at last year's Houseware convention.
So it's basically a song about a guy that goes to a Tupperware or a housewares convention and the debauchery that he gets into. So
I am driving this year's Lamborghini as opposed to last year's top of the line BMW. Oh my. I can't believe you don't know what I do. I said I can't believe that you don't know what I actually do. I said I got you. I don't you know. I smell Tupperware.
So yeah, and it goes on and on and on. I won't subject you to the whole thing. Oh my god! But that was the famous Tupperware song. We had such a good time with that. I want to incorporate more into our show. I really do. I'm gonna try and figure out how to incorporate some more of the music from my old band in the show. It's just, I don't know. It's all very, yeah. When you're trying to put music in, you want a certain feeling, but oh yeah, no worries, man. Welcome back. Hey, I'm almost done, but it's good to see you. No, I get being busy, man. It is a thing. So yeah. So man, closing arguments tomorrow early in the morning. And then we get verdict watch. So yeah, that's going to be interesting. I hope, Katie, you have some good luck tomorrow. Keep us updated, please. Oh yeah, no, it's all good, man. Appreciate you stopping by. We just, today was the charging conference. Wasn't much. There was a little bit going on, but tomorrow, man, this is going to the jury. I can't. It's finally. It's like we're getting to the jury, and so it's time to hopefully put this to. We can finally say Karen Reed is free. I really do. I really hope that we can get there. Oh yeah, man, I smell that tacos over there. So Turtleboy. Okay, we can go over real quick here. Why not? Heck it. All right, so this was basically the moment. Yeah, no, exactly. That was it's that song is definitely that way. All right, so share. This was the moment we saw. So basically, Turtleboy was in trouble for supposedly. So the day of one of the all right, let's go back to Mikado's. A second. So this trial was only supposed to take like a day, right? Or 2 days. But it took like 3 days and it was stupid. So here's some of the pictures from Jess. So basically he showed up at court for one of the hearings. The person who put him in jail originally showed up with the restraining order, right? And basically walked in the courtroom like, ha, 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 ha. And he left, right? He left. He did what he said. He went to the police. He said, where can I stand? It's 100 yards. And so, yes, absolutely. No, we won't block you. Sorry, I misread that for a minute because no, we will not. We will not block you. So yeah, so she basically used this thing as a crudgel to say you can't be near me, and so he went. This thing, the screwed up thing is the court took him. I mean, the Commonwealth filed charges because they said, and their argument was, well, a restraining order is a restraining order, and he came within 100 yards of her, so he should go to jail. That was their. Oh my God. Oh, Machado. Oh, okay. Thank you. I didn't know that. Machado. All right. So this was the moment of the verdict.
Agent Carney, under a bench trial, you have been found not guilty as to one charge of violate abuse prevention order. Such charge will automatically be sealed by the Office of Commissioner of Probation and the Clerk's Office unless you notify the office in writing within 10 days that you do not want to charge steal.
So yeah, so 3 days just to be found not, I mean, it was ridiculous. The whole thing is ridiculous. And then I think that'll be the next trial. Yeah, no, he definitely is. I mean, when is his trial? I don't even think they have a date set for his trials for witness intimidation. I don't even think they've got those set up for a trial yet. So, I mean, they're still making motions and stuff on that. That was just to keep a anvil over his head, right? He's got this anvil that's sitting up over his head and it follows him everywhere he goes. And so, I mean, they tried to put him in jail for calling out Tully, right? The thing he said about Tully. Oh, we're going to put you in jail for that, for what you said on your YouTube channel. It's like, you know, you can say that, you know, he has no filter. You can say that he, you know, as far as like decency, it's like, that's one thing. Well, you know, I don't know. I don't know that some of the other ones wasn't a, yeah, no, this was definitely not a felony, but it would still put him in jail. I mean, they would still lock him up for God only knows how many days. So the trial is going to be, yeah, no, he doesn't. That's the thing is you cannot agree with his methods, and you could not agree with some of the stuff that he says. And like I says, he rides that line, and sometimes he kicks that line, and sometimes he just throws himself over that line. Does he? But there's a line of like, you know, but you know, there's a line of what am I trying to say? Like common decency. We know that he kicks that line over all the time, but then there's a line of legality, right? And so the First Amendment is a broad swath, and that is a very broad line. And I don't know that anything he's done really gets, you've got a First Amendment argument on a lot of that. You really do. And, you know, I think, I don't know. We'll see. Hopefully those trials are televised and we get to watch them. So, yeah, but not guilty today. I'm sure, you know, Paul O'Keefe even came in and testified, and, you know, there was like 8 or 10 witnesses in this thing. It was unnecessary. So, yeah, no, exactly. Right. It's, you know, he is definitely not any of those things. He says exactly what comes to his mind. And so you got to respect it. Got to give him respect for that. So, okay, on that note, now I'm going to go get tacos. It does not care about your feelings. It does not. It just, yeah, it should be very, 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 very broad to have anything that crosses that line. Yeah, no, exactly. There is I agree. That's probably not the best thing to say, but you're also, if you're getting targeted by the state, if you're getting targeted by the state, yet you still stick to your guns and you stick to what you say, it's retaliation for everything that they think he's done, because he brought a lot of attention to this case. He brought so much attention to this case that it's, you know, it's undeniable that, and he literally found some of the evidence that it's good. I like to yak. So he literally found a lot of the evidence, you know, besides the stuff that the feds found. He found other things to give credence to a defense that, hey, you, Karen Reed, you do have a defense here. And so I think he started, he started down this path. He got Yannetti some early stuff, and then, I mean, yeah, it's oh yeah, no, exactly. He did too. He got a lot of people to follow. Like I heard about this case, and I heard about him through Ricada. Back when Ricada was Ricada. And so I saw him on Ricada that night, and I started following this case, and I'm like, holy crap. And the more you dig into it, you're more like, what the hell's going on? Those are not from a taillight. So, okay, taco time for me. I'm going to change up. What are we going to do? Let's watch Tony Miller from the Bureau Undermining Misinformation on our way out of here. Little introduction video, and yeah, we're going to get back to editing. Like this weekend, we're going to be editing the crap out of some stuff. So, okay, tomorrow we will have us some closing arguments, and then we'll be here for that. So, we'll be watching it later after the thing, but we'll it's tomorrow's Friday, so we'll have Michael and Jody. Oh my goodness, that's right. So we'll see what we actually get to tomorrow. Who knows? And it's Friday the 13th. It's Friday the 13th. So, okay, who knows? Tomorrow's a potpourri of craziness. So, all right. Good night. Goodbye. Have a great day. Katie, I hope everything works out for the doggies. So, yes. All right, bye.
Introducing Agent Anthony Tony Miller from the Bureau Undermining Misinformation.
Welcome to the office, huh?
Agent Miller takes the mission seriously with an eye toward the future.
Retirement, man. One word only.
You don't look that old. How long you got?
14 years, 5 months, 7 days. Give or take. Who's counting?
When it comes to finding misinformation, Agent Miller brings his A game.
It's obvious. Dude's not right. Nolan Ryan, way tougher than Roger Clemens, period.
Agent Miller is also a master of the interrogation.
I say we just let him stew for a little bit. We'll go catch some coffee, eat some food, maybe check the scores. Then we finally go in. I'll take some notes, but really they're just doodles. But I'm getting really good actually at some sketches. I'll show you later.
Is there anything I can do for you guys?
Chicky nuggies.
Agent Anthony Miller, performing the mission of keeping us safe from dangerous misinformation.